Protecting your assets in divorce can begin before you get married. If you have children from a previous marriage, a family business, or assets that you acquired before marriage that you would want to protect in the event of a future divorce, entering into a premarital agreement may be an option to consider. Parties to premarital agreements can agree to virtually any terms, so long as the terms do not constitute illegal acts and are not against public policy. In a premarital agreement, parties can agree on how they wish to divide marital property should they divorce or one spouse die. The parties can also agree upon the amount of alimony a spouse will receive or whether a spouse will receive any alimony at all. The only limitation is that a judge may override the premarital agreement if a spouse would be eligible for public assistance upon separation. For a premarital agreement to be enforceable, that is, valid in a court's eyes, certain legal requirements must be met. First, both parties must sign the contract voluntarily. Courts generally interpret this requirement to mean that the parties clearly understood the terms of the contract, the written terms accurately represented their intended agreement, neither party was tricked, forced, or coerced into signing. Second, both parties must fully disclose their assets and debts to one another before signing. And third, the contract must not be what the law calls unconscionable. An unconscionable contract is one in which one party unfairly obtained the signature of the other and in which the terms are so obviously unfair that they shock the conscience. The most common defenses to enforcement of a premarital agreement are that it was not voluntarily executed, that it was signed due to fraud, misrepresentation, duress, or undue influence, or that the agreement is unconscionable. However, the fact that one party was not represented by counsel or that the agreement was not presented to the party until the eve of the wedding does not necessarily make the agreement void or unenforceable. Rather, North Carolina courts consider the totality of the circumstances surrounding the execution of the premarital agreement, including such factors as the relative education and business sophistication of the parties, whether each party had an independent attorney, the timing of when the agreement was negotiated relative to the wedding date, and whether adequate financial disclosures were provided before the agreement was signed. If you have a question regarding whether you need a premarital agreement or whether a premarital agreement you executed is enforceable, you should contact a qualified family law attorney to discuss the specific facts and circumstances of your case.